Hello, everyone, and Happy New Year's. My name is Giovanni Nogales, and I am a paralegal here at Lyles Parker. Welcome to today's webinar hosted by the Texas Association for Home Care and Hospice. Today's webinar is entitled Overview of the HIPAA, Privacy and Security Risks Faced by Your Agencies in 2025. Today's presenters are Heidi Kocher and Matthew Catoe. Heidi is an expert in all aspects of compliance and privacy programs, including developing and deploying policies, procedures, and training. Her experience includes serving as a Chief Compliance Officer and a Chief Privacy Officer, implementing the various requirements and aspects of corporate integrity agreements, and responding to and defending audits from Medicare, Medicaid, and private insurers all the way up to the ALJ level. As for Matt Catoe, he is a new associate at Lyles Parker. Prior to his time with us, he worked with HHS and OIG, both their investigation team and with their Office of Counsel. Since he come back from the dark side and brought experience in anti-kickback, Stark Law, and False Claim Act compliance matters. This is just a quick reminder. If you have any questions throughout the presentation, please feel free to type them in the chat box, and we will address as many as possible at the end of the presentation. So without further ado, I present to you your speakers, Matthew Catoe and Heidi Kocher.
Thank you so much, Gio. Really appreciate it. Can we go to the next slide, please? Of course, since we're attorneys, we got to do a little quick disclaimer at the front. This webinar is for general information only and does not constitute legal advice and should not be used as a substitute for seeking legal counsel. Legal advice is always tailored to the specific circumstances of each case, so outcomes can and do differ based on specific facts. If you have a very specific question to your situation, please consult with your own attorney. Thanks. Next slide. So as the description of the webinar indicated, we have quite a wide range of topics to consider, and for that reason, this is more of sort of a 2024 in summary and an overview of what is coming in the future rather than diving into specific topics in great detail. But I think there's still a lot of meat here simply because there has been so much happening in 2024 that I think you will see this has got to have been some kind of a banner year for HIPAA enforcement. So what we're going to talk about is briefly some recent regulatory changes. Matt is going to talk about key case law and enforcement actions. Again, there is such a wealth of case law and enforcement actions out there that we're not going to dig into too much depth, but just need to give you a flavor of what is happening out there. Some specific challenges for home health agencies and hospices, which I'm sure you are quite aware of. Some enforcement trends and compliance strategies, and then practical takeaways, and a conclusion looking forward. So next slide, please. All right, so I wanted to just kind of cover some of the issues going back a little bit further through the pandemic because they're really impacting what is happening today. As you're all probably aware, once a regulation goes into effect, there is a period of a year or two before the regulatory agencies usually start enforcing it. And that's kind of what has happened here with many of the rules that affect HIPAA. They were put into place a couple of years ago, and now they are starting to be enforced, and OCR and HHS are doing investigations. So some of the things that we want to highlight is the interoperability and the information blocking rule. This rule is from 2021, and it really focuses on data sharing and patient access rights. This is, of course, very important because, you know, in theory, your EHR systems will talk with the hospital's EHR or a physician's EHR. Even if you're on a different system, and we don't rely as much on faxing anymore, which just shocks me how much faxing still goes on. This has some ongoing issues, of course, with broadband availability in rural Texas, which is really impacting the data sharing and patient access rights. Information blocking basically has talks about when a healthcare provider must give electronically formatted health information as opposed to paper information, and puts in a number of requirements for how to timely and appropriately share information with patients in an electronic format. This is, of course, a challenge for any agency that is managing decentralized data. You have folks in the field, so how do you get all of that information into an electronic database and make it usable to others and available to patients on a timely basis? So that's one of the things that is now starting to come up in terms of enforcement. The second thing is telehealth flexibilities. Those flexibilities were all set to expire on December 31st because, you know, the COVID pandemic is now over and done with. But there was enough of an outcry about them so that some of them were extended to March 31st, 2025 by the continuing budget resolution that was signed. If you were paying attention to the news, the talk was all about government shutdown, but that bill did have some extension of the telehealth flexibilities. And one of the specific things that it explicitly extended was the use of telehealth to conduct face-to-face meetings for a hospice recertification. So be aware that that is now available until March 31st. What happens on April 1st still remains to be seen if they will extend that further or not. Another thing that is happening is the states are really stepping into the privacy field. And these state laws really will interact with HIPAA requirements, and particularly if you have any agencies that are operating across the state lines. So you folks who might have branches in New Mexico or Louisiana or Oklahoma, these state privacy laws really come into the fore. And they're also creating sort of a wraparound about HIPAA. If you think of HIPAA maybe like a candy, right, then the state privacy laws wrap around that or form an additional layer around that. And what we are starting to see is that it is not always clear which sets of laws apply, and the states are being pretty aggressive in enforcing their own state privacy laws. So a key example of this has been California's Consumer CCPA and CPRA, Consumer Protection Acts, that are specifically addressing data handling. Everybody looks to California because those have been in effect the longest, and so many states are modeling their state laws on that. And we just had a Texas law come into effect on July 31st of 2024 that is in this field as well. Next slide, please. The other big thing in 2024 specifically was the reproductive health care privacy rights. There was rules issued in April that prohibit the sharing or disclosure of reproductive health care information in certain circumstances. And be aware that reproductive health care information, the way it is defined, is actually very, very broad. Most people have said that this is in the context of abortion and those reproductive rights, but the way that is defined, it is actually much broader than that. So if you have an elderly gentleman, for example, who has erectile dysfunction. That could technically fall within the definition of reproductive health care information. So again, this was just put into place, and we'll see where this is going. There is Texas litigation on whether or not this rule is enforceable under Texas law. That litigation was just filed at the end of the year, so it hasn't gone very far yet, so we don't know where this is. But be aware that this rule does require covered entities to obtain signed attestations from the recipients of the reproductive health care information that certain requests for that information aren't for a list of prohibited purposes. Again, most people kind of focus in on this in the abortion context and shield laws and so on, but it really is broader than that. Part of this actually requires all covered entities to modify their notice of privacy practices to support these privacy rights. The due date for that is actually in February. Again, we shall see where this goes because we do have Texas litigation, and of course, in about 2 weeks' time, we will have a new administration who might either seek to overturn this law or not enforce it. But do be aware that you should probably be looking at your PHI sharing processes and whether or not you need to modify your NPP. And again, just because you're either a home care agency or a hospice does not mean that you do not have reproductive health care information in your records. Again, remember, it is rather broadly defined. Also in 2024, we had the Federal Trade Commission. They expanded their definitions in their health breach notification rule to apply to a broad range of health and wellness apps, and also that a company's unauthorized disclosure of such health information can constitute a breach of security under the rule. Again, this is different from and broader than HIPAA. This is things like information that might be gathered via your website or information that is coming from wearable devices. So there's a lot of stuff to look at here as well. And again, just like the state privacy laws, the Federal Trade Commission's rules wrap around HIPAA. They extend the field of covered information much more than HIPAA is. And also who is responsible for this. Again, HIPAA is just covered entities. This addresses things like the developers and marketers of data apps and so on, and data brokers. Really extends who is responsible for maintaining health information security. Next slide, please. We also had a final rule on the confidentiality of substance abuse disorder records. These are actually the Part 2 regs. That's how they're known. And the Part 2 regs specifically address drug and alcohol use records or disorder records. And what this final rule did is it brings HIPAA and Part 2 into greater alignment, and it's intended to increase the coordination among providers who treat patients who have a substance use disorder. And again, this is not limited to those providers who treat explicitly patients with substance use disorders, such as chemical dependency centers or mental health specialists. This kind of talks about any provider treating a patient who has health information on substance use disorders. And so this again applies HIPAA now more broadly to the kinds of records that are covered by Part 2. It's intended to enhance the integration of particularly behavioral health information with other medical records and also increases civil enforcement penalties for the improper disclosure of such records. I mentioned the state privacy laws already, and the Texas Data Privacy and Security Act, which became effective July 1st. I'm sorry, I think I said July 31st. Again, this protects sensitive personal data, and it specifically covers certain health data that is excluded from HIPAA. So again, something you need to be aware of. Next slide, please. Matt, do you want to start talking about some enforcement?
Sure. So we're picking it up at the beginning with OCR, the Office of Civil Rights. It's been very active in HIPAA enforcement in recent years, and we don't see any real indicators that they're going to stop, even with the new incoming administration. We would like to speculate, but we just don't know at this time. There's too many unknowns in the air. In the year 2024, there were over 22 enforcement actions completed, which is the second highest in all of OCR history, collecting a total of $9.9 million in fines and settlements. For those of you who are more math inclined, 22 enforcement actions, raking in just under $10 million in fines and settlements, should serve as an illustration of how quickly these matters can get out of hand and how expensive they can get for individuals who are not in compliance with the OCR's guidelines. The Federal Trade Commission also settled 4 matters involving data brokers selling precise data locations, and similar to the Metapixel cases that we will get into later, there are 2 cases that involve the collection and sale of health information for specific advertising purposes. The Texas Office of the Attorney General specifically also made a settlement with Pieces Technology Incorporated, a facility that was using artificial intelligence to summarize patient conditions and treatments in order to submit claims, and it was specifically related to the claims' accuracy and lack of, quote, hallucinations that caused the action to go forward. Next slide, please. So there was also a very big Primera Blue Cross settlement. There was a phishing email that allowed hackers to access the IT systems for over 9 months. Primera was determined to have failed to conduct a necessary enterprise-wide risk analysis and implementation of risk management. The breach exposed $10.4 million, or 10.4 million records, excuse me, and resulted in a $6.85 million settlement with the OCR. There is also a class action lawsuit associated with Primera's breach that resulted in a $74 million payout for the class action. That is a separate and additional fine or penalty that you can view in addition to OCR. The lesson here is to prioritize regular risk assessments, especially in the cyberspace. It's very annoying, it's very confusing, but it can get exponentially out of hand very, very quickly the more any kind of outside threat actor is allowed to access any PHI they're not supposed to have access to. Another example on your screen is the Athens Orthopedic Clinic. Now, I had the privilege of working, I believe, for the insurance carrier for Athens Orthopedic Clinic while this matter was going on. It involved a $1.5 million fine due to failure to implement proper HIPAA safeguards for safeguarding patient data. There was an allegation that several bad actors, for want of a better term, were able to interact with the Athens Orthopedic Clinic system in such a way as to not only gain access to information or materials they're not supposed to have, but also later exfiltrating that data, pulling it from the system in such a way as to it's now out there in the world, and the exposure and the risk associated with that proved to be a very big target, for want of a better term is the best way to frame it, for OCR enforcement actions, because the patient information was leaked in such a way as to be exposed into the dark web. This leads us into OCR actions on the right of access. There is the other side of the coin. Patients are allowed, if they have proven, if they've gotten through all of the necessary multi-layer security protocols that the 2 previous cases inspire, they are entitled by law to their medical records. as is anybody else who is duly authorized and appropriately allowed to access these records. There were at least 50 settlements in the year 2024 for providers failing to provide patients with timely access to these records. That means in a reasonable amount of time. The implications lead into timely compliance for home health settings. You cannot just let a generic request for records go by the wayside, because if the patient brings an action for failure to provide timely records, there is a possibility that the OCR comes knocking on those grounds. Next slide, please. So we mentioned in a previous slide the Metapixel and data hacking investigations. Metapixel is a technology that was utilized to track website users' IP address and a little bit of associated medical information to generate targeted advertisements via Meta platforms, be it through Facebook or any other Meta platform, Snapchat, Instagram, anything under the Meta umbrella, for want of a better term. Over 80 plus lawsuits were filed on the grounds of inadvertent access to private health information, and I believe a majority of them are still ongoing, related to not only the HIPAA concerns of the right to access the private health information, but also the cyber sphere as to what it means to use this pixel tracking, this technology, should it exist at all? If it does, in what world should it be checked? What are the limits and what are the outer safeguards? It's a very rapidly evolving field, but it is a very dangerous field in terms of risk exposure, making sure that all hospice and home health agencies need to make sure that nobody is touching the PHI that's not supposed to be in there. The Anthem settlement of 2020 is also on your screen. Prior to the Change Healthcare incident of 2024, this was the largest healthcare data breach in the U.S. history. It was a phishing scam that tricked an Anthem employee to essentially inadvertently deploying malware across the Anthem systems. It took over a month for the Anthem teams to find that malware, and then they had to act accordingly. Until the Change Healthcare, this was again the largest breach. It resulted in a $115 million class action settlement and a $16 million settlement with the OCR specifically. Again, the numbers on your screen are meant to serve as red flags and warnings of making sure that the HIPAA environment, or the field in which home health and hospice providers keep their electronic health information, is secure at all times. Because the first people the OCR is going to point the finger at is the agency whose job it is to maintain those records. And it can get very expensive very quickly. The lesson from the Anthem settlement is to secure remote communication tools, especially for those, as Heidi mentioned earlier, who have satellite branches that may stretch across state lines. Next slide, please. So this is the big kahuna driving the ship, for want of a better term. Coming out of 2024, we had the Change Healthcare cyber breach. The breach was determined to be a failure to implement multi-factor authentication across a variety of older systems in the Change Healthcare cyberspace. Over 100 million patients have been affected across the greater continental United States. There is shaky numbers on any international liaisons that Change Healthcare might have done business with. The numbers are too murky for us to state definitively at this time, but they are expected to be in the lower millions as well. The current cost ongoing to Change Healthcare is rounding $2.5 billion with a B dollars to Change Healthcare. Change filed the breach report on July 19th of 2024, 5 months after the breach occurred. And there are rumors, though none of them have been substantiated, that that was done deliberately so as to throw OCR off the trail. Again, none of those rumors have been substantiated, so we cannot say for certain whether or not they are or are not factual. But the rumors are that they deliberately delayed the breach notification in an attempt to do damage control behind the scenes. And it was only once the breach had reached threat level 0, for want of a better term, that they had to notify the OCR. On November 19th, they find...
Let me just jump in here as well and say that when they filed the breach report, they reported that 500 individuals had been affected, because that is the requirement for, you know, a large data breach. But they used the number 500 because they still do not have a firm grasp on exactly how many patients were affected. So just from that standpoint, there's going to be lasting fallout and continuing fallout from the Change Healthcare breach. Sorry, go ahead, Matt.
No problem. So the takeaway from the notification report is it is always safer, generally, to notify OCR as soon as a breach is identified, rather than get caught, as Change did, with several questions as to why did it take so long for the notification to occur, why is it only, as Heidi just pointed out, the bare minimum, and how many people are really affected. The inability to answer these questions really brought Change into the OCR's direct crosshairs, and is, as you can see, patients are still, to this day, being notified that their records have been exposed. We are still grasping at the outer limitations of this breach as it has occurred. Now, I have the privilege of working with I'm sorry, go ahead.
I was going to say, I actually, about 2 weeks ago, got a data breach notification letter from Change, and I have no idea how Change was managing my healthcare data. I'm suspecting it was, you know, one of the providers was using them as a clearinghouse. But yeah, I mean, even I have been affected by Change Healthcare.
Yeah, Change Healthcare. It is a case example that will likely go down in history books across disciplines, because it affects the clearinghouse and the financial side of it. As Heidi was mentioning, Change at its core is an insurance company. So there's the financial aspect, but they deal with private healthcare information. There's the HIPAA aspect. This was a cyber breach. There's the cyber aspect. And it's all tied up in the healthcare space of who has access to what records and why, which is where the legal and the regulatory and the healthcare laws all come into play. And due to the sheer scale of this breach, we hypothesize that any and all major overhauls in rules or regulations, especially as it relates to healthcare, cyber, and HIPAA enforcement, are likely going to stem in some form or format from what we find to be the fallout of this breach. Now, I have the privilege of knowing several individuals who are in Change Healthcare's department. I can't get into the specifics of what they know and don't know for obvious reasons, but I do want to point out they state that it is an older system that was hit. That is not, and we bring that up here specifically to point out that just because you're not using the latest and greatest EMR, or you haven't recently updated any kind of servers in your own organizations, there is still a very real risk in HIPAA exposure for cyber attacks. And we want to advise everyone in the home health and hospice space to keep a constant and safe audit on your cyber environments. We understand it can be annoying, it can be frustrating. It's one more thing to add to the checklist. But if Change Healthcare leaves you with nothing else, it should be the bright, shining example of how quickly and how exponentially these matters can spiral absolutely out of control. Next slide, please. So the specific challenges that these pose for home health agencies, we've identified a number of ways that we can boil all of this information down into specific risk areas to focus on. The first is any and all mobile workforces, nurses, doctors, medical directors. If they have data transmission capabilities across their mobile devices, their smartphones, their laptops, someone takes work from home when they're working on holidays, we need to make sure that we're securing data transmission across those devices. This can include, but does not necessarily require, VPN access to access EMR systems, private Wi-Fi or secure locations, Ethernet plugins to specific routers or or devices that are encrypted so as to not allow third-party outside access. The specific response of securing a mobile workforce is unique to each home health and hospice agency, given the resources that everyone has at their disposal, but the primary concern is always protection. If the individual trying to access this PHI record does not have A, their name on this record, B, authorization from the person who has their name on that record, or C, a legitimate authorized medical reason to access that record, they should not in any circumstances be able to touch the record. This goes to the following remainders on the screen: data decentralization, telehealth platforms, and increasingly high turnover rates. Making sure to keep up with consistent training, awareness programs, and ensuring compliance with ongoing and evolving HIPAA standards will help keep any organization out of OCR's crosshairs, which is where everybody wants to be, not in the spotlight. It's a very hot seat and it gets hotter fast. Vendor management is an interesting locale. BAAs, third-party billing, IT, and EHR system compliance oversight all fall within the parent organization, i.e. the person holding the records or generating the records on behalf of the patient. That means it falls to that organization and someone within that organization to check the third-party billers, the IT teams, the EHR or EMR systems, making sure that they are up to date with their HIPAA compliance, and that, as we mentioned previously, there needs to be a reason to access the records or nobody touches them. Next slide, please. So these enforcement actions also leave us with a variety of lessons, some much scarier than others. We've identified that we want to point out for home health and hospice, there's increased scrutiny on smaller entities, as though home health and hospice agencies do operate with less resources than individuals like Anthem or Change, they have equal accountability, which means the law applies the same, and the penalties, regardless of how big the practice is, are the same across board. If OCR or any of their corollaries in the federal government decide to throw the book at your operation, it can get exponentially higher, which is why we're going so into detail on the penalties associated with it. Data breaches are the big one. Most of the enforcement actions we brought up in earlier slides are brought on by data breach. That means a third-party actor from somewhere in the world that's not the agency got access to PHI that they are not supposed to have. Most ransomware incidents are targeting smaller agencies because they know that these smaller agencies don't have the resources to put up an ample cyber defense the way individuals like Anthem or Change would. It's just an easier target. This means that it falls to the home health and hospice agencies to enhance your cyber defenses where you can, and make sure that everyone is clear on if a breach occurs, who does what, the standard who's on first, who's on second speech. If a breach happens, a clear and concise plan of action will save you so much headache. I say that both as a lawyer in my current capacity and previously having worked cyber breach insurance on the other side of the house. If you have a plan and it's a good plan in place and everyone does what they're supposed to do on the event of a breach, the amount of hurdles that you can get ahead of cannot be overstated. It makes everything so much easier if you can turn over to your malpractice carrier, to any investigation arm, to any lawyers, anybody who's got to come in and now respond to this breach. If you can say, we've already done A, B, C, 1, 2, 3, because we were keeping an eye on the news, it cannot be overstated how many hurdles you can get in front of and save yourself the headache of having to deal with that in real time. This plays into the final two examples on your screen: vendor agreements and incident response failures. Each of them have their own risks. Vendor agreements need to be compliant with all HIPAA requirements, and incident response failures, going back to Change Healthcare. If you notice a breach, odds are it's going to be better to bite the bullet and tell those individuals who need to be told so that you can mitigate the damage, whatever it may be, as opposed to letting it stew and cook the way Change did, because among all of the exposure lawsuits that they're currently facing, once again, there are unsubstantiated rumors that they deliberately delayed their notification to OCR, and that has its own pot of litigation that is brewing out of it. Next slide, please. That plays into vendor management as well. It kind of plays into, like we were saying, you need robust agreements and compliance verification for billing, IT, and other providers. The short version is, if you or a member of your agency is not directly controlling it, you need to have pretty tight controls on the individuals who are, and making sure that there are liability limits where there need to be some, and HIPAA compliance throughout the entire contractual arrangement. Excuse me. The big goal, as you may have noticed behind this, is to get ahead of technology and the emerging threats that are associated with it. Most providers are behind the times in terms of security technology implementation. That's not a condemnation or an insult, that's a simple statement of fact. Most of the providers on this webinar, or who will review this for their education, went to med school. They want to operate on patients. We didn't go into school for compliance or regulatory procedures, and yet it's a matter of who gets hit with the lawsuit when it comes in the door, which leads to providers needing to up their, at the very least, base knowledge of general technology security. Ransomware attackers, again, are targeting smaller entities known to have limited defenses due to sheer resource strain. AI is an emerging field. There are several questions about what it is, what it's going to do, and what its place is, if any, in the US healthcare space. And there are also questions about quantum computing as we move into the year 2025. A lot of it is very nebulous, and most of it, again, will likely stem from whatever comes out of the ultimate resolution of what the Change healthcare crisis currently is doing. But there are areas that, if you can flag it and have some kind of compliance or general information upkeep in-house, it helps you stay ahead of the curve, and therefore, once again, out of the line of fire of the federal enforcement agencies. Next slide, please. There are, of course, challenges with these compliance procedures. The first is interoperability, seamless data sharing. As anybody who's done EMR, one EMR system to another can tell you, interoperability is a nightmare on a good day. And implementing secure interoperability with other healthcare providers who don't use your systems or are external to your organization poses a challenge in compliance. Anywhere that can be shored up or tightened up, pardon me, should likely be looked at for compliance purposes. There are, of course, resource constraints and staffing issues and technology budgets. We can't make the business decisions for you, but we just want to advise you that these organizations, the Office of Civil Rights, any of their corollaries in the DOJ, very, very rarely pause for the amount of resource constraints or compliance arguments. They don't care. The best way to frame it is, if any part of the organization touches any federal dollar at any point in time, that dollar comes with a whole host of terms and conditions. Whether they're fair or not is not the question when the OCR comes knocking. It is the fact that they are enforceable. So resource constraints, staffing issues, and technology budgets are not going to get you out of the line of fire the way most people would like them to, because it comes with the territory of HIPAA enforcement and compliance. And we understand it can be a drain on an agency's resources. So we want to point out this challenge in compliance going into the new year. Next slide, please. Finally, the emerging technologies, again, going back to AI, what it is, what it's going to look like. Should it be in the healthcare space, yes or no? And if it does come into healthcare, what does that look like? Remote patient monitoring under the extension of telehealth that Heidi was mentioning earlier is also in the OCR's crosshairs. And the risk of adopting new tools such as mobile health apps on smartphones without any proper vetting. What does that compliance and that exposure look like? are all questions that we are currently sorting out as we head into 2025. And of course, cultural barriers are always and likely always will be a challenge in compliance among geographically dispersed field staff. Next slide, please. But we do have good news. I'm going to pass it back to Heidi, and she's going to help walk through some strategies for robust compliance and what it looks like. How can you actually address this rather than all of my doom and naysaying? Heidi?
Thank you, Matt. So what I'm going to talk about in terms of strategies for compliance and practical takeaways, I'll be honest, this isn't likely to be anything that you haven't heard before. But I think one of the things that has come out of the enforcement actions is, and Matt can verify this, we have this drumbeat from OCR of certain major failings in every investigation that they do. And one of the primary ones, I've lost count of how many times this has come up, is that the healthcare provider has failed to conduct a proper security risk analysis. So that is number one on our list. I mean, again, I've lost count of how many times we see in the notifications and the settlement agreements that the healthcare provider failed to conduct a proper security risk analysis. It just happens over and over and over and over and over again. You need to be doing these annually or after significant operational changes. And significant operational changes can be things like changing a location, switching to a different EMR. Switching billers can be a significant operational change and means you should be conducting a revised security risk analysis. For home health and hospice agencies, you really want to focus in on mobile and remote access vulnerabilities, particularly staff device uses. And here's the thing, you can do a security risk analysis yourself. OCR has put out some materials, but here's the thing, those materials are a floor, not a ceiling. And the way I look at it is this, can I clean my own house? Yes, I can clean my own house. Can I mow my own lawn? Yes, I can mow my own lawn. Do I want to mow my own lawn in the heat of a Texas summer? Heck no. That's why I pay a lawn service. That's why many of us have cleaning services, right? Because we have much more important things to do. You can actually outsource security risk analyses for very reasonable prices. We have some resources if you want to contact us separately. But this is probably the biggest thing we see, that there is a failure to do a security risk analysis. So if there's one thing you take away from today's webinar, it's conduct an SRA. The second thing that we run across is there is a lack of vendor oversight. And often this is a failure to conduct any kind of due diligence and verify the compliance of your business associates. And that would be, of course, the billing and scheduling and PT systems. It could be your independent contractors. For example, if you've got PT or OT therapy services, you'd be surprised what falls into the definition of a business associate. And one of the things that we see is, again, I've lost track of how many times we've seen this in the settlement agreements, is that there was not a business associate agreement, or the business associate agreement was not correct for that type of business. So you want to make sure you're doing the vendor oversight with your preliminary due diligence and then a business associate agreement. And in the contract you can sign, you should be including specific terms about data security. Don't leave it for just the business associate agreement, but put it in the main contract as well. And with the vendor oversight, again, you need to be asking questions. Do not rely on what the vendors have told you. As you saw in one of the cases, the Pieces Technology Inc., the company said its hallucination rate was less than 1%. And hallucinations are where artificial intelligence returns information that is not correct or accurate. So they claimed that their hallucination rate was less than 1%, when in fact it was much higher. So you need to ask questions about if you're using something like an AI tool, what are the hallucination rates? How do they come at that? Have they tested this in real life, right? Ask questions, do your due diligence. The third thing that we see, go ahead.
If I can jump in, it's less a matter of direct oversight. We like to stress it should not be your job to police a third party. The question is not it is not a responsibility your agency takes on. It's a trust but verify. It's you want to outsource and you want to believe in them and you want to trust them, but do you want to risk being left holding the bag if and when enforcement comes down the line, which is what Heidi is driving towards, of ask questions to make sure that everyone is doing what they're supposed to do. And if you have misgivings, address them quickly so that you don't end up in the next version of these PowerPoint slides.
Yeah, I think that's a great point, Matt, and a great analogy. Trust but verify. And the reason for that is because ultimately you are the covered entity. It is your data. You are ultimately responsible for that. You can shift some of the liability and responsibility to your business associate, but only if you have done some of this preliminary due diligence and oversight, as Matt notes. I think that's a great point. The third thing that we see is training programs, again, in all of these resolution agreements. There may be training, but it is limited training. It is not extensive enough. And again, sometimes people just don't even get the training. We find this to be the case a lot in healthcare because there are a lot of part-time and PRN people. So somebody may have, let's say you have a nurse, and that nurse has a main job working in a hospital, but then once or twice a week does some services for you or is PRN. And the tendency has often been to say, oh, they're covered by their HIPAA training at their primary job. Unfortunately, it doesn't work that way. You cannot rely on other healthcare providers' training. You have to be training anybody in your workforce, regardless of what their other employment or job options are. And again, you need to tailor these training programs for your home health staff. Much of the training that is out there is very generic. So you want to focus in on not just handling PHI on site, but also out in the field. This is going to change what your training looks like. And you should be including scenarios that involve things like inadvertent disclosures in patient homes or elsewhere. Again, some of your providers are not necessarily going to come into the office and upload data. You know, maybe they have an iPad or a laptop at home. What are they doing with that? So include that in your training programs. Another thing that we are recommending is what we call proactive monitoring and audit trails. Your EHR systems almost all have access and modification logs. You need to know how to access and look at those logs, and you should be reviewing them periodically. Again, this is proactive. That's how you figure out that somebody perhaps has been accessing your EHR at times when they should not be. You can also get at this to some extent with user-based roles and access based on user-based roles. But again, you want to make sure you periodically pull access logs from your EHR and review them. And in addition, you should be asking your IT vendor for some advanced IT tools to scan your network and detect and hopefully prevent unauthorized access. One of the prior slides actually had some, I'm looking here back to my prior slides, there was an issue with the failure to do this kind of monitoring. Break-fix services no longer work. I have run into so many people who say, yeah, we kind of handle our IT in-house. You know, we have an IT service provider, sort of, but, you know, we only call Joe's Computers if something breaks and we can't fix it on our own. The train has left the station on that. I don't think break-fix services anymore are good enough. And what we are seeing is more and more requirements that you have advanced IT tools to prevent access and exfiltration of data. Next slide, please. In conjunction with that, you want to make sure that your technology solutions are secure. You want to use HIPAA compliant telehealth and EHR platforms. And there are actually lists out there, and you can look up to see if your EHR meets requirements. It pretty much, most of them pretty much do. But if you want to just, you know, include that with your HIPAA compliance program information, it's a nice thing to do, because what it tells OCR, if you're ever audited, is that you know enough to go and ask the right questions, and you've thought about that. You, of course, want to encrypt data on all mobile devices. Again, the train has left the station on encryption. Make sure that all your mobile devices are encrypted. That's another thing that we see in the resolution agreement. Matt mentioned earlier incident response plans. You want to, again, have figured out how you react if you have a breach, who you notify, and how to remediate it. Now, some of those things will change based on, you know, anything that happens. If you have an insurance company, your insurance company may take it over. But you need to at least figure out in at least the 24 or 48 hours how this works. What is the method for escalation of a concern? Who is going to be the point person internally? You really need to have thought through this and, you know, do tabletop drills, you know, think about them. If you have a meeting of management, make one of the meetings and say, okay, we're going to pretend we've had a data breach. How do we handle this? You know, let's run through our incident response plan, our policy and procedure, and make sure that it works correctly. Because it's like when you're supposed to do a fire drill in the house. If you have a fire drill in the house, that's not the time to figure out if the windows have bars on them or locks, or how you get from point A to B. Remember, I remember when we were kids, we were taught to feel the door if it's hot in the hallway, right? Close your bedroom door and feel if it's hot. If it's hot, don't go out into the hallway, go out from the window, right? Those are the kinds of things you need to test. And in your incident response plan, be sure to involve an attorney. It doesn't need to be us. Whoever your attorney is fine, but things can very quickly spiral. And as you've seen in a number of these case reports, there is invariably a class action lawsuit that happens. There's a lot of considerations about who you share data with and not during your notification and remediation, and you'll want to have an attorney guide you in that process. Another thing you can do is leverage cyber insurance. First of all, everybody should have cyber insurance, but read your policy and understand what it covers. If you've seen one cyber insurance policy, you have seen one. Every one that I have read has been different in terms of what triggers coverage, how coverage is granted, how much they cover. I mean, you'd be surprised. And you want to make sure that the coverage really aligns with your specific risks of home health and hospice operations, you know, including, again, the fact that you are out in the field a lot. People may have devices in their vehicles or at home, and you really want to think through how you manage data breaches and ransomware in the home health and hospice field. Next slide, please. You want to make sure you do policy updates. Again, you want to regularly update and review privacy and security policies to reflect operational changes. The recommendation is that these be reviewed on an annual basis. Again, you don't necessarily need to update them if they have no need to be updated, but you want to have some kind of a record that you at least review them on an annual basis. You want to develop relationships with IT vendors. Again, the way this is going, managing your own IT, unless you are large enough and have really good IT people available to you. If you're a small agency and you do it on your own, or your cousin's son is your IT person, the 15-year-old is your IT person, not good enough anymore. And yes, I've actually run into that. Similarly, people often retain IT services only for a break-fix basis. That's no longer going to be good enough. There is too much at stake here. You need to develop a relationship with an IT vendor who can deploy software solutions to, again, detect and prevent unauthorized access. The hackers are extremely sophisticated. They will run circles around you in terms of IT savvy, so don't do it on your own. Make sure to vet any technology that you're looking at. Scheduling apps and patient portals should meet HIPAA standards. Again, the patient portals usually do because often they're part of a certified EHR, but some of these other apps might not be, and you want to make sure that they are HIPAA compliant. Another thing that we are going to put on the radar screen here is data offshoring. We are seeing states beginning to prohibit data offshoring, and these are especially via the Medicaid contracts. Texas specifically and explicitly prohibits data offshoring if you are a Medicaid contracted provider. CMS is requiring Medicaid Advantage plans to provide attestations to CMS about protections for offshore data and the use of offshore vendors. And of course, if a Medicare Advantage plan has to make an attestation to CMS, you better believe that they have those requirements either written into their contracts or other policies and procedures about that. So beware that data offshoring is starting to become a big issue. Next slide, please. Again, emerging trends and risks, we've kind of mentioned these already. We've got AI and automation. The algorithms don't always comply with privacy regulations. You need to make sure that you understand what AI algorithms do and don't do. And there's a lot of risk for data mismanagement in these automated tools for scheduling and patient monitoring and completion of records. There's also an awful wealth of patient-generated health information from wearable devices. Things like Apple Fit or your Fitbit are now starting to generate patient data. So beware of those as well. And that can include some of the things with the remote patient monitoring as well. Those connected devices and wearable devices, make sure you understand what the risks are and how that data is secured. We've got Internet of Things. We have compliance challenges with connected medical devices. Again, we are starting to see more and more connected medical devices. Things like, again, the blood pressure machines that automatically transmit data. That's an example. We've got emerging risks with third-party services, including cloud storage solutions. So remember Change Healthcare. Again, Change Healthcare was a third party. They were a business associate, often doing much of it. They were also a covered entity because they were a clearinghouse. So you've got a lot of risks of third-party data handling and storage. You need to understand what your third-party services are, and again, be aware of data offshoring. Next slide, please. Finally, you want to minimize your data. You want to limit THI exposure to what is necessary for care delivery. Again, you can do this through user-based access. I forgot what the movie was called, but you want to do encryption everywhere all the time, right? You want to encrypt all devices and communication channels. The technology is out there. There is no longer an excuse not to encrypt. You also want to have privacy by design. You need to think about privacy as you are implementing new workflows and technologies. You want to think about how privacy is achieved from the get-go. Privacy should not be an afterthought. And finally, again, auditing your data privacy and security practices. OCR has said they are restarting audit programs, so you want to make sure that you are up to snuff with what those requirements are. Matt, next slide. I think you want to wrap up for us?
Sure. So going into 2025, the primary concern is, of course, the trends that we've seen and generally where we kind of want to ballpark the incoming administration. We do want to point out that, without passing judgment on the incoming administration or not, the rules are likely to change just because it is a change of party in power. So please keep an eye on the risk areas that we pointed out with HIPAA and OCR throughout this web deck, and making sure that you're staying in compliance. We cannot say for certain what the rules will be, but it's a pretty safe bet that someone is going to alter something somewhere in the federal regulatory enforcement schema. And once again, as we've reiterated throughout this web deck, the responsibility to stay compliant ultimately falls to your home health or hospice agency. The trends that we've pointed out in this web deck are increased enforcement with specific focus on mobile healthcare providers, usually in the telehealth space, especially as Heidi pointed out earlier in the presentation, likely sometime around late March, early April when that extension expires. We will likely see an uptick in enforcement, though what shape that will take and what it looks like, we don't know enough to speculate. There are a number of technological innovations that, from a consumer standpoint, we're very excited for. From a legal standpoint, they open up a whole host of regulatory compliance concerns that we want to encourage everyone to keep an eye on, making sure that you're staying up to date with what is okay and what is not okay. We recommend continuous staff education and adaptation of best practices in the same way that everyone has to keep up with certain certification requirements for medical licensure or certificates. Just roll this into the batch, just making sure, you don't have to be the expert in the field, but you should know your way around a compliance plan, a breach response event, and a breach response plan in the event there is a breach, and the general basics of who do I call and when. We encourage open collaboration between compliance, IT, and all field operations. And once again, as Heidi and I were discussing earlier, we do not expect any medical facility to take on the role of cyber compliance. We do, however, want to point out that OCR will first point to the entity whose job it is to create and maintain the PHI records. And to that end, any billing provider, company, cyber, anybody that you work with, trust but verify. Hope that they're doing a good job, check to make sure that they are. There is a notice of proposed rulemaking going out on January 6th of 2025 that we predict will cause a significant increase in technical requirements as it relates to most medical record keeping, and home health and hospice are not expected to be exempt from those new rules. Again, this is likely in light of the Change Healthcare incident, as that is still ongoing at the time of this presentation and still evolving into new and previously unexplored or not so fleshed out fields that are now very much in the center of the OCR crosshairs. Finally, we have noticed an uptick in OCR restarting their HIPAA audit program, going to several areas that Heidi pointed out earlier in the presentation, The primary focus appears to be security risk analyses, whether your organization took preemptive steps to mitigate HIPAA exposure or risk, what those steps were, how often they occurred, and how readily your organization responded to a breach in the event there ever is one. And I believe that takes us to the last slide. Next slide, please. Yes. So we went over a lot of information in this web deck, a lot of areas of concern. There was a lot of doom and gloom. We provided what strategies we could, but we now want to open it to questions for anybody who may have them.
Yeah, there's a few. So there is one specific that says, we are a third-party billing company who does not release medical records, only billing records. We often receive authorization for release that are signed and cited prior to the date the reproductive health care became effective. Are we required to request updated releases, which include patients' authorizations that include the reproductive privacy rights?
Are these standing authorizations or one-time only? It's not clear to me from that. If it's a one-time only and you have already released the records, then I don't think there is an issue. If this is a standing authorization, then yes, I would recommend you go back and look at your procedures and see how to incorporate those requirements from the reproductive rights healthcare rule into your procedures.
Yeah, I would second that, just kind of citing of how long is this authorization in place and how many times per fiscal year are you tapping it. As Heidi mentioned, if it's a standing document, you want to keep it in compliance for however many times you use it. If it's a one and done, I think, you know, that it's in the name, one and done, and then I don't think there would be any reason to be concerned.
Yeah, that's the only question that we have. Other ones are just saying, are we going to get the PowerPoint slides? So yes, the PowerPoint slides are going to be sent out tomorrow. And do you guys have anything other to say before I close out?
Happy New Year, and make sure you get your SRAs done.
Yep. Happy New Year. Check, trust but verify. Everyone wants to be friends, but you don't want to be caught holding the bag.
Right.
So that concludes today's webinar. Thank you guys for joining us, and thank you to our speakers, Heidi Kocher and Matthew Catoe. Everyone from today's webinar, like I said, will receive a copy of the presentation tomorrow via email to the email that you have used to sign up for this webinar. If you have any other further questions about today's discussion or another healthcare law issue, please feel free to reach out to us, to the speakers, or directly to Louds Parker. Have a good Wednesday and Happy New Year's.
Thanks all. Bye-bye.
Thank you.